role in that, although she will be doing some different work for us in the coming months and be doing actually representation of detainees, because we've just been awarded a grant that will last for about 5 months and allow us to provide kind of public defender services in Batavia for a while. So that was going to keep her busy, I think, for the next 5 months, and I don't know how much all of you will have contact with her, but I'm sure she'll be available for advice from time to time.
Well, good morning. Thanks for sticking around. Like Sophie said, I do mentor a lot of attorneys that haven't done this kind of work. So I'll say in my presentation, VLP will provide you samples of documents, walk you through. If you cannot meet with your client on a regular basis and you need a couple of questions, if we're at the facility, we will take the time to meet with them and follow up so that you don't have to do that back and forth travel. So please know that when you take a case from us, we are a resource for you. We're not just going to give you the PowerPoint and send you on your way. So I'm going to talk about the practical things. In other words, you know, okay, I'm going to I'm here, I'm at the CLE, I want a case. How does it happen? And what do I need to do to get started?
And I'm going to tell you a little tidbit. Jessica used to work for Phillips Lytle many years ago, and she took one of these cases for us, won it, and then came to work for us permanently.
That probably won't happen to you. We just hired someone. Don't worry. I did. This was my first exposure to immigration. I took a cancellation of removal for a Spanish-speaking client who was a long-term permanent resident from Mexico. Cancellation of removal, as Sophie mentioned, is immigration relief that is available to certain kinds of individuals. They're permanent residents, that person with the green card that she talked about. So where your proceeding is going to take place, if your client is detained, they're going to take place in Batavia. If they're not detained, if they pay a bond, and I'll talk a little bit about bond, they'll go to Buffalo. How do you go to court? If you're going to Batavia, you do need a current photo ID. Don't take an expired license or passport. What happens is you drive up to the facility and you go through a security gate. There you show your ID. Very often, the officer will ask you for your bar card. Some states give a bar card. So you might have, if you practice before the county court or the city court, you may have, you know, your attorney card that you flash so you don't have to go through security. That will serve perfectly fine as your bar card, your photo ID. Know that to take a case, you've got to file what's called a Form EOIR 28. So you'll hear us refer to it as your E28.
There's a copy in your material.
Your E28 is the document that tells the court, I'm the attorney for this client. So the EOIR stands for Executive Office for Immigration Review. That's the office that handles the immigration court cases. The judge is an officer of EOIR, so you're submitting to EOIR a notice of your representation. That's the first form that starts everything for you. For cancellation cases, the second form you'll need is the cancellation of removal application. That's an EOIR 42A. So these two are the principal forms that you'll need when you're going to handle this case. I will, when it's time for you to take a case, sometimes the respondent or the client will have already started their application because, as I'll explain, we try to get them to start thinking about their own case and do some legwork for you because it is their case principally. So this is the second form that you will need to file with the court. This is the application that they file to ask for cancellation. So I want to go over that first form, the E28, that gives the court notice that you're the attorney. There's name and address. Of course, that's the client. Their address will be the facility. Then there's a name and address for you. And then there's something in the middle of the form that asks for, again, your bar number. In New York, that's going to be the attorney registration number on your receipt. So when you pay your OCA dues and you're registered, you're going to put that registration number in that box for your bar number. I tell you this because sometimes the clerks in Batavia or Buffalo will reject the E28 if there's no bar number, even though technically New York doesn't have a bar number, you have a registration number. So fill that in. Look on your OCA receipt and just write it in so that you don't have any problems when you submit this form to the court. The next number that you need when you sign that you're the attorney on the form is a spot for your EOIR ID number. This is fairly new within the last 2 years. EOIR, that's the Executive Office for Immigration Review, established a registry. They're basically trying to keep non-attorneys or non-accredited representatives from taking cases and providing maybe some faulty representation. So this is kind of a step that they've taken where you register online that you're an attorney. So it's called e-registry. It's like signing up for, you know, any number of things that we sign up and give all our contact info and then a password. So what happens is you sign up as an attorney. You're going to fill in your registration number. It's online, and what happens is after you send it, to get that number, you've got to go and present yourself with your ID to the court clerk. So they want to confirm your identity. So you're going to submit it online. You're going to go in person to the court, EOIR location, to validate your identity. You can go to the Buffalo court, so even if your case is in Batavia, you know, once you register, it'll pop back a message by email saying you can go and have your identity validated. You can go to the Buffalo court, and I will give you the number, tell you who to call and what to say when you go to the window so they can validate your identity. And after that point, you get your EOIR number via email. So they send you an email to activate your registration, and that's the number that goes right there. Yes?
Is that something we can do now before we're assigned a case?
Yes. Great idea. Because sometimes it takes a little bit of time. You can certainly go and see your client without having this number. In Batavia, it's our experience that if you're a pro bono attorney, maybe you registered but you don't have the number yet, they'll let you appear. But that's not always the case with every single clerk. So if you anticipate, you know, an immigration practice, or if you just want to be ready, I would highly recommend registering, and I'm happy to send you the link. So you're going to go online, you're going to get the email, you're going to go to Buffalo, you're going to get your number. That's just the process. It's not too complicated, but if you forget everything that I've said, just call. Don't worry about it. But when I send you a case, I will say, did you register, or do you need to register? And I just want you to know what I'm talking about. Okay, practical tips for referring. How do we give you a client? If you're taking a cancellation case, you're going to hear again that anyone who's a non-citizen can be removed, just like Sophie mentioned. They may be deported due to certain criminal convictions. So if you get a cancellation case, your client is a green card holder that's going to have a criminal conviction. So if that's something that you don't want to deal with, and I have had attorneys say, I don't want to deal with criminal convictions, then we give them an asylum case, or we give them just a different kind of victim-based case. So just know that that's the kind of case that you're going to have if you have a cancellation case. There will be at least one, could be minor under the state law, but at least one criminal conviction. If your client's detained, what happens is VLP meets them in what's called an LOP, a legal orientation program. We're funded to do this program on a weekly basis at the detention facility, where we give kind of a know your rights presentation to every detainee that enters. Also detainees that leave us messages and want to attend the orientation, we see them and give them the information. That's where we initially meet them. Sometimes they get out, and so they pay their bond and they're out. We like to refer people that attend our orientation, because then they have a basic framework of their rights. Not all green card holders are going to be able to apply for cancellation of removal. So you'll know that if you get a case, your green card holder is going to have a criminal conviction, but they're also going to have had that green card for at least 5 years. They're going to have lived in the U.S. for at least 7 after their initial admission, and they're not going to have something called an aggravated felony. So these are the things that we screen for. We screen for eligibility. So if you get a case from me and it's a cancellation case, you already know they're going to have some time some ties to the United States. And those ties are going to be the basis for your evidence, your evidentiary submissions. You don't make the eligibility determinations, like I said, when you get it, that'll be the kind of case that it is. We like them to come to the orientation, we screen them, we interview them individually, and we sometimes ask them to go to their first court so they can get the evidence that the Department of Homeland Security is going to file against them. Sometimes we ask them, go to your first court, bring me back the papers, because those papers will often tell us if there are other crimes that might take them out of eligibility. And that's something that we want to see before we give them to you. We love for them to attend a workshop where we give them that application that I talked about so they can get started and have some ownership over their case. They have to present need, they have to consent to our sharing their information with you. And what happens is you'll get a referral memo, maybe a lengthy email describing the case, now that we have their permission to speak with you, and then asking if you'd be interested in taking it. And as Sophie mentioned, we'll give you a time frame as best we can so that you can ensure that you will be available. The first piece of paper that starts the case is the notice to appear. So when the individual is detained, they're going to see the judge. The judge will have this document about them. The document will essentially set out the allegations that the government has against them to show why they are removable. This is what DHS gives to the judge to say, this is why this person should be deported. So then the judge wants to know from the client, who is called the respondent in immigration court, wants to know from them, are the charges true? Charge number one is always, you are not a citizen or national of the United States. As Sophie mentioned, it's a civil case, so it's not a crime to not be a citizen, but that's going to be reason number one why they can be deported, because U.S. citizens can't be detained or deported. Does that make sense? So charge number 2, 2, 3, and 4 will always have to do with their entry, status, and any crimes that they may have committed that have put them in this situation. Again, this is the form, and this form is going to be like a treasure trove for your direct examination. For those of you that have never done a trial direct exam, your form is going to be your best friend. You're essentially going to make your questions follow the form, because you want to make the information on this form come out in an organized way to show that this person deserves to have their removal canceled and stay in the U.S. Cancellation of removal is discretionary, so it's all about, do they deserve a second chance to keep that green card and have their removal canceled? So your direct examination will talk about things that are right off the form. Are you married? Where did you get married? The form says the marriage took place in. My spouse currently resides at. The date of my marriage is. So you're going to say, are you married? Yes. Did you get married? So your direct will really come off of this form. So if you've never done a direct, just know that the form is going to help you organize your direct examination. If you have done one and you're happy to format your direct, then by all means do, but just know that the form itself is going to give you a lot of organization. The form will ask about their employment, information about their family, children, where they've worked, when their children were born, have they paid taxes. All of this is on the form, and all of this is what you want to bring out to the judge, because these are the reasons why they should be allowed to remain in the country with their green card, because of their stable work history, because of their marriage, their children, their payment of taxes. The form's going to ask, how they entered the U.S., and it's going to ask, it's going to note, I have or have never been arrested, summoned into court, imprisoned, placed on probation, forfeited collateral, on and on and on. It'll ask them all these questions, and that's the part of the form that will be brought to life by the opposing counsel. Department of Homeland Security is going to want to talk about those crimes. So in your direct, you're going to ask them those hard questions. You want to ask the difficult questions of your client. Have you ever been arrested? Why? If there's, for instance, a drug possession, have you used drugs? How long have you used drugs? Have you gone through any rehabilitation programs? How does the court know that you're not gonna go back to using drugs? And so those are the very difficult questions that you wanna ask your client, because you wanna bring out the good in light of that conviction. You don't want DHS, the Department of Homeland Security attorney, to be bombarding your client with hard questions about their crimes. So that's gonna be the hardest part of your preparation, because your client will sometimes feel like, why are you being so hard on me? What's the deal? I thought you're my attorney. But it's your job to bring out that difficulty, so that on cross-examination, when the government has their turn to ask them, they've already admitted to their crimes. They've already talked about why they committed them. And so it'll make it easier for them to show that they should merit a chance to stay in the United States. You're going to have a couple of weird questions on the form, and just ask them clearly. So you need a yes or no from your client. You'll see, have you ever been a habitual drunkard? Everyone says no to that. But sometimes you have a long list of DWI, so you might want to reconsider. You might want to say, it is in our best interest to always be honest on these forms. We want the judge to give essentially a waiver and cancel our removal no matter what we've done. We want everything to be in this application, because we don't want the government down the road to say, oh hey, we found this old crime. The judge didn't waive it, so we can use it against you now. Those convictions, everything needs to come out for cancellation, because cancellation is a remedy only afforded one time. So these are the, all of the information on your form is going to be information that you're going to ask your client directly and bring up in your direct exam. It's all about a balance of equities. The judge is going to look at the bad, which are the conviction records. DHS attorney is going to focus on the conviction records and the underlying bad behavior, and you're going to bring everything good. You're going to try to provide a balance. It is your job to make your client look more than a man who's in a colored jumpsuit with a couple of papers that talk about his criminal conviction. That's all the judge has in front of him. It is your job to make that client come to life, to be a father, a neighbor, a Little League coach, whatever it may be, whatever positive equities that individual can bring. It's very, it's all about discretion. So sometimes when my clients don't boast about themselves, they don't talk about helping their kid after school or helping with homework. It's kind of like a drama. It's kind of like a soap opera. We want to know every little good thing about you. We want to know some bad, especially related to your criminal conviction, your underlying behavior, and why you're rehabilitated. But we want to know all the good, because sometimes it's a little good thing that the judge might really connect with that person and see them then as a person with a family that merits an opportunity to stay in the country. We want to establish that he warrants relief as a matter of discretion. You'll see some of these cases in your materials. These cases give a really good framework of a cancellation case. So you'll know that you'll note in matter of CBT, this case is in your materials. It's the job of the judge to balance adverse factors. So when you talk to the judge about your client, you're going to say, Your Honor, we recognize these convictions, these bad behaviors, but we also ask the court to balance. So feel free to use the words of the case law to help you make your arguments, especially if you've never appeared in front of the immigration court and you want to use the language that the judge is going to understand. There's no threshold requirement that you show any outstanding equities. Basically, we want the judge to weigh the good and the bad, and you want to try to tip that good scale. How do you tip that scale? You want to show positive family ties. So birth certificates, marriage certificates, maybe baptismal records if you can't get the actual state certificates. You want to show history of employment, W-2 forms, letters from former employers. If the respondent will have a job waiting for him when he gets out, it'd be great to have a letter to show the judge that he does have a future employment ready to go into. What kind of documents demonstrate the family ties? Letters of support and photos are really helpful. like Bob said, keep your envelopes so you can show where they came from, especially if that witness isn't going to be able to come, you want to show where they're writing from. I cannot tell you how much it helps to have a photograph of the respondent with his child, and when he's smiling and fully dressed. You know, we want to say, do you have any pictures of you with your kids? Oh, yes, I do. And they come in, do you have any pictures of you with your kids when you have your shirt on? So just know that those are the kinds of conversations that you're going to have. These are people. These are real people. Maybe you're used to, you know, a higher caliber of a client, a business person, you know, someone that owns, you know, a lot of property. These are going to be real people, and if they qualify for our services, they're not going to have a lot of financial equity. So just enjoy yourself. You know, get to know them. They are worth the time. We talked about certificates. Payment of taxes are really great. Any property ownership, I mean, it's rare, but sometimes there's a home that may be, I had a client who purchased a home for his parents. So while the home was not in his name, it was in his parents' name, he paid for it. And so I had the parents bring in the documents about the home, and even though it was all in their name, then they testified that he had made the payments for them. So that was a huge equity. He didn't own the property, but it was a tie to property that he had provided for family members that were in the U.S. Vehicles are property that should be included. Contributions to the community are really important because when you're tipping that scale, you want to show that your client is a contributor to the community. Not just to his family, to his employer, but to the community of the United States. That's the language that's in the law. So we want to know, is he a volunteer firefighter? Has he ever worked, you know, painting houses for, you know, not-for-profits in the area? Has he ever been a coach? You know, this one's my favorite. iPod, I paid. You know, sometimes the clients pay for things in their community. You know, maybe their neighbor is a single mom and their little one needed something in particular and he bought it because he's just that kind of guy. And you don't want to, you can't really say that yourself. You're honest, this is a great guy, look what he did. So you want him to say it, and you know, you want his humility to come out, you want his personality to come out. Sometimes when you first meet them, they're angry, and it'll be for you to lead them through in that direct examination to show who they really are. So I think that's the most satisfying part of the work, that you really show who they are. Their education definitely matters. Even if they went to education programs that were part of their probation, those matter because they can show rehabilitation. Again, going back to, if you win today, how does the judge know that you're not going to go back to that kind of criminal activity? So anything to show a foundation for skills is very important. Also, any clubs, religious organizations, accountability groups, campus groups, mission work, anything like that that can be attributed positively to the respondent is really good material. Letters of support are always helpful. Again, when they're on the stand, you're going to ask them about their crimes and how they know they're not going back there, and we want to elicit some kind of responsibility. You know, sometimes the best answer is, well, that was really stupid, and I'm sorry, I'm not going to do it again. And sometimes that's really all they can say, because you do have some crimes that are minor under the state, but then put them in a very serious position under the immigration law. So the judge is going to, again, decide, does he deserve cancellation of removal? He's going to look at how long the applicant has lived in the U.S., family, community ties, community service, membership in clubs, religious organizations, work history, filing of taxes, accepting responsibility. This is directly from the case law. So when you're submitting this, these are the exact kind of equities that the judge expects, hopes to see concerning the respondent. So when you start your case, you're going to complete the e-registry. You're going to review the documents that we give you, which will include a referral memo and that notice to appear, so that you know the charges that the individual is facing. You're going to meet with the client, and if you'd like to meet with me, I'm happy to sit down with you and talk about it and give you samples. You are going to prepare the application and the supporting evidence. Sometimes we have interns that are happy to help at BLP with this. If you need assistance, again, we will provide a support for you. I will give you, we will all give you sample exhibit lists, witness lists, and relevant motions. So you can see what a filing looks like. You can see what it is that you have to put in your motions. You'll prepare your client for direct testimony at the facility. We'd ask that you meet with them at least twice before the hearing. You'll prepare their witnesses for direct testimony. Witnesses can be prepared via telephone. And then you'll do the individual hearing, that direct and rehabilitation. If we get a case right away, sometimes you might be able to go to the master calendar hearing, that initial hearing that's kind of like an arraignment, where the respondent is going to tell the judge, I want to apply for cancellation. Eligibility is determined, I want cancellation, the judge will give a hearing date. We will try to give you the case very early on so that you can have the option of attending that master calendar to advise the court of your representation and seek cancellation of removal. If you're not available to attend that, that's something that we can cover. And I just covered one last Monday, and I explained to the judge, Your Honor, this case will be referred, so we will submit a motion to substitute counsel. And so then the judge knows that, you know, he can expect someone else to do the hearing at the individual hearing, but we want to cover that just to get it on the record and schedule. That's where your schedule comes into play. If you're not going to do the optional initial appearance, then we want to know from you what your availability is like so that we don't get the hearing scheduled on a date that you're not available. As for bond hearings, if the client is eligible for a bond and you want to cover the bond, I'm happy to go through that with you individually. Typically, our clients that are green card holders and are eligible for cancellation are subject to that mandatory custody that Sophie talked about. But if they are eligible for a bond and they want to be moved from the detained docket to the non-detained docket in Buffalo, we'll certainly show you how to conduct a bond hearing. It's a very short, again, why the client deserves the bond. A lot of those papers that you'll need for cancellation will come into play for the bond. And then the judge will determine the amount of the bond. If the client pays it, the case will be moved, and then your timetable gets stretched far out into the future, a couple months, maybe even a year, unless, of course, we do get a new judge in Buffalo. For your individual hearing, let's say you show up and your witness brings a really important document, really great letter of support, or the tax returns that you've been waiting on. At the individual hearing, the judge will allow you to submit outstanding evidence as long as you can explain why you weren't able to submit it in advance. The judge will always set up a call-up date, a date when your evidence is due. So all those documents that we talked about, the judge will want to see them in advance of the hearing. Sometimes it happens, certainly, that the witnesses bring a valuable document, and so you can do an oral motion to submit that at the last moment before the hearing. You can do an opening statement if you like. Then you'll handle the direct exam of any witnesses that your client has. You'll rehabilitate their testimony because they'll go first, and the government will ask hard questions. And then sometimes if you feel there's a need to rehabilitate your client's answers to only the government's questions, don't go into something new on your rehabilitation. But if you want to address something that the government asked about, then you can do that. You don't have to. If there's not a need for it, you don't have to. And then you can do a closing statement. Please know that in immigration court, you give your closing statement, and then the government gives their closing statement. It's typically the other way around in defensive proceedings, but that's how it works in immigration. Individual hearings are very short. They're either 9 to noon or 1 to 5. The judge can continue them to complete a testimony, or if you finished up really late, you finished up right at 5 or right at noon, the judge can continue it to give their decision. It's best to get an oral decision the same day. You want to, for instance, I will try to skip the opening statement if I know I have a couple of witnesses and I want to squeeze it in. And so watch your time. Prepare your client to answer directly and honestly and clearly. Because you love to finish, so there's time for an oral decision. Because an oral decision when you win, he goes home that day with the witnesses, his family that have come out to testify in support. And so then he's released and goes home that day. As Sophie said, if your case is denied, always reserve your appeal.
Is that one case with 3 hours or 4 hours?
Yes,
That's what you said before,
one case. So you get started, and essentially you go in there, and the judge says, is there anything else that's outstanding you want to submit? And he'll go through the record and talk about what's been marked, what's been received into evidence. So you don't have to lay a foundation for every document that you're going to talk about. In other words, you can say, Your Honor, I submitted with that application some supporting documents. I'd like those documents admitted now. And the judge will say, okay, DHS, do you have any objection? No, Your Honor, or yes, Your Honor. It's very rare that they do. Then I receive them. They're marked as such. So you can refer to them. They're already admitted. You'll want to, and again, when I give you samples, I'll let you know that you need to page number your exhibits so that when you refer to something, you can refer to the page number and build your record that way, because everything is recorded. But you don't have to lay that proper foundation for every document you're going to ask them.
Except in Buffalo. In Buffalo, I'd be prepared to do that, to
Yes.
have them admitted one at a time, the
One at a
foundation. In Batavia, they're very good about doing them as groups, and only if the government objects to a particular document within the group, then you might have to argue its probative value or whatever. But in Buffalo, I would be prepared to submit them one at a time with the proper foundations.
And those are going to be the cases that bond and then are moved to the Buffalo non-detained docket. Of course, in Buffalo, the judge won't necessarily give an oral decision. Might say that they're going to send you one in writing, and you're not as, you're not in a rush because the respondent's not detained at that point. So if the case is continued, that's not necessarily great for you because then your representation continues, or for the client because then the case is still ongoing. But that option is there if they're not detained. Most of the cases that I will refer to you will involve detained cases.
Jessica reminded me of something that I want to mention because she's way ahead of time. Very good, thank you. What happens with our clients who are cancellation eligible because they're permanent residents with criminal convictions by definition is that many of them have come out of the criminal system and they've become very savvy about the criminal system. And one of the things they've learned in the criminal system is you never admit what you did. It's contrary to criminal representation. And what we have to work with them a lot when we're at the cancellation stage is you've been convicted. That means, you've either pled guilty or you've been found guilty by a jury or court. When you come to us in the immigration world, everyone in the immigration world, the attorneys, us, the attorneys on the other side, the judge, we're all taking it at face value that you are guilty. The judges in immigration court don't want and should not be relitigating the criminal case. So we get initially, so why'd you do this? And we'll get, I didn't do it. It was the other guy's car. Oh, I don't know where the drugs came from. Or, I really got screwed by my defense attorney. You gotta shut them down at that point. Stop. You took a plea of guilt, you're guilty, and everyone in this system believes you're guilty. The purpose of this is for the judge, the immigration judge, to weigh and balance the equities against the negative factors. And one of those is to determine whether you are a recidivist and whether you understand your wrongdoing. And you have to be able to explain to the judge that you understand your wrongdoing. That's the first part of kind of taking ownership. And then what plans you have for the future so we don't find you in this immigration court again. So you gotta work a lot with our clients, especially the ones who've been through the system on that point. Okay? It's very rare that you have to take the Fifth Amendment anytime in immigration court. It's come up once in my career where we were talking about the possible prosecution for a crime that I advised the client not a word because obviously the district attorney could then get my records from this. But that very rarely happens. Usually we're dealing with crimes that have already happened. There's already been convictions. There's no issue of guilt or innocence. And they will not relitigate, and they will really get upset, immigration judges, if your client is trying to relitigate his culpability by saying, it wasn't me, I was hanging out with the wrong kind of people. They don't like that. They want them to take responsibility. And that's a huge component of working with these clients, because very few of them come with that. They're used to talking in the, I didn't do it, I'm innocent, whatever.
We have had difficult crimes. For instance, we had a client who had a endangering the welfare of a child conviction. And, it was his story that his stepdaughter had made up these allegations because they were having difficulty in the relationship, he and his mother. And so he took the plea to not put her through the system. That was not a good story as far as we were concerned. But the stepdaughter did come to testify in support, did write a letter of support, and her mother, who was not in the relationship, also corroborated his story. So that was a very unique instance where he took the plea for her good, and the judge, fortunately, sided that way. And so it's exceedingly rare, and we really try to just bring them off that ledge of I didn't do it, because we're already past that point. Yes?
Do you handle cases regarding the children?
I do. I handle the cases involving a child who is unaccompanied minors in the U.S. They are not going to be, they're not going to be this kind of cases. They don't have a green card. So the initial, just the eligibility has to do with a permanent resident for cancellation. Is there something specific you
When
want?
do those take place?
Where? Those children are not detained. So if they're before the Buffalo court, there's a juvenile docket where the judge sees the juveniles on particular days and times, but they are not detained in Buffalo. There's no children detained in the Buffalo area. They are certainly detention facilities for children in other parts of the country, but not in Buffalo.
Do you use pro bono lawyers for those cases?
We are just starting to, yes. I think I've referred two, and one is in the process, and it's I'm very protective of my children, as I call them, and so I really like to have, depends on him, depends on how old he is, did he go to school, will he understand that I just screened his case, I told him that this is what's going to happen, and now he's going to have somebody new to deal with that doesn't speak Spanish most of the time. So it depends on the child, whether or not we will refer a case.
Yeah, most of them are Spanish-speaking kids. They're from the, Central America, Mexico. So the other thing is we often like bilingual lawyers for that purpose.